No, why don't we wait, Ravi? Only 5 people,
Yeah,
including us.
that's okay.
Okay. Okay.
Good morning and good afternoon, everyone. So this is our webinar series, specifically focusing on professional services. In this forum, basically trying to address some of the immigration challenges and especially the young professionals who are migrating to US and having all those challenges they're going through. We thought that this is a good session that we can have, and planning on sharing this with rest of the community and get some maybe perhaps they get some help. So today it's my privilege to introduce the speaker, Mr. Krishna Baireddy, an alumni of SRKR. He's a class of 2006 in mechanical engineering and IIT Madras in ocean engineering. He's a researcher specializing in the design and development of mobile offshore drilling units, also called MODUS, and offshore wind turbine installation vessels, WTFs, in Houston, Texas. So, with over 17 years of experience in the offshore engineering sector, he brings a deep technical expertise and a global perspective to his work. As a US green card recipient under the EB1 category, Mr. Baireddy has first-hand experience navigating the complexities of the American immigration system. His own journey as a non-immigrant worker facing the uncertainties of the green card process inspired him to help others on a similar path. As a founder of Way to Green Card LLC, he is dedicated to guiding individuals through EB1A, EB1B, and EB2 NIW petitions, as well as O1A visas and adjustment of status applications. His mission is to make the green card process as clear, efficient, and stress-free as possible, empowering others to achieve their American dreams. So, with that, I will turn it over to Krishna. So, I will stop sharing. I think go ahead and share your screen, Krishna. Thank you.
Yes. Sure, Ravi Garu. Thank you for the introduction. Let me share my screen. Yeah. Good morning, guys. My name is Krishna Baireddy. I have done Bachelor of Engineering in Mechanical Engineering Department from SRKR Engineering College between 2002 and 2006. And then I did my Master of Science by Research from IIT Madras between 2006 to 2008. From 2008, I'm working for offshore oil and gas industry for design and developments of mobile offshore drilling units and offshore wind turbine installation vessels. I received a green card sometime back under employment-based first preference outstanding researcher category, and I own a professional services company called Way to Green Card LLC. At the end of the presentation, I'm going to discuss how we help at Way to Green Card LLC for the high achieving professionals. Today's session is about bringing the awareness about different visa categories which are available for high achieving individuals. Most of our Indian professionals are concentrating on H1B visa, which is having there is a per year cap, and it is also based on the lottery. So depending on lottery system all the time, it may not be the best choice for us when you have high achieving, like you have contributed something significant to your field of endeavor. That is the reason I want to bring an awareness. I want to discuss about the benefits and eligibility criteria of different visa categories in the coming slides. Disclaimer: we at Way to Green Card are not attorneys. We do not provide any legal representation. If you need any legal advice, you should consult a licensed immigration attorney in USA. We are going to discuss today benefits of immigrant visa categories EB1A, 1B, and EB2 NIW, and benefits of non-immigrant visa category O1A, and eligibility criteria for all these visa categories, and green card application process, and brief information about how USCIS adjudicator review your immigrant or non-immigrant visa petitions, and what we do at Way2 Green Card LLC, and what kind of services we are going to provide at Way2 Green Card LLC. This is visa bulletin for October 2025. If you look at the final action dates and dates for filing employment-based preference cases, the wait time, the priority date, the current dates for EB2 and EB3, second and third preference, which are at 2013 and 14, which is a decade back, and backlog. And at the same time, in reality, it takes like anywhere between 2 to 3 decades to become your priority date current. Whereas the employment-based first preference, the dates for filing is April 2023, which is like 2 years behind. So if you prefer to go with employment-based first preference, when you have high significant contributions to your field of endeavor, then you should go with employment-based first preference, so that you will get a green card in very shorter duration. And there is another benefit by going EB1A. If you have a priority date from EB2 and EB3, you can just port that date to the EB1A. You can use for adjustment of status. So there is no wait time or lesser wait time based on your priority date. This
Krishna,
one, the benefit.
Can I ask a quick question, Krishna? Can you go back previous slide?
Yeah, sure.
So can you explain the difference between the top table versus the bottom table? What's the difference?
Yeah.
Final action date versus the date of filing?
Yeah, final action date, the dates for those dates, the visa is available to approve. For example, if you take employment-based first preference, 15th February 2022, so it means that up to 15th February 2022, whoever filed, they will get the green card. And if it is in the below table, there is a dates for filing, which is 15th April 2023. So who are having the priority dates before 15th April 2023, they can file I-485 for adjustment of status.
Got it. Thank you.
So if you file your priority date before 15 April 2023, you can file your I-485. If your priority date after this date, you have to wait until it comes to that date. The dates for filing gives you the information to file your I-485. The final action dates table give you the information about the visa's availability till what date. So that is the basic difference between those two tables. Is it clear, sir? Okay.
Yes. Yeah. Thank you.
Benefits of employment-based first preference green card category EB1A. EB1A is for extraordinary ability individuals in the fields of science, arts, athletics, business, and education. Unlike EB2 and EB3, for this particular visa category, you don't need to file labor certification, and it allows for the self-petitioning without needing a job offer or employer sponsorship. And since it is a first preference, the wait times are less. If you have a priority date from EB2 and EB3, you can port that priority date to EB1A, so that you don't need to wait for your priority date become current. And family benefits, your spouse and along with your children who are under 21 will get their green card if your EB1A petition is approved. And then priority processing, since it is a first preference visa category, and direct pathway to green card for the foreign nationals who are not having any kind of visa to the USA, but they have a substantial merit and they have a sustained national or international acclaim. In that case, they can choose to go with EB1A. And if their petition is approved when they're in the foreign nation, they can come to the USA through the green card directly without having H-1B visa or F-1 visa or any other kind of visas. It is a direct pathway to green card.
So in other words, it's a directly somebody can apply from India and without
Correct.
coming here, right?
Yes.
Okay.
So they can apply from India, EB1A immigrant visa petition I-140. Once that is approved, you have to check the dates for filing and final action dates to make sure like your priority date is current to file your I-485. This is a visa consular process for the people who are outside USA.
Yeah, consular process. You have to go in the Indian consulate to get the
Correct.
green
They
card.
have to go
it
to
was
the
there
USA
earlier.
embassy in India,
Yeah,
and then
yes.
once it is approved, then you have to come to USA. Then within 3 months, you will get your green card in hand.
So I don't know if this is the right time to ask one more question I have. Earlier, I had some people working, suppose, for example, somebody working in Deloitte in the manager level. If you want to come here, you can do EB1, some kind of specialized category to speed up the green card process I had earlier. It still holds good? Somebody want to move to Deloitte in the US, if suppose he's in India and Deloitte is working. Only special category people are allowed to do that.
Yeah.
Is it still
So
applicable? Yeah.
I want to tell you like one more thing here. Under EB1A, there are like 3 subcategories. One is under EB1, there are 3 subcategories. One is EB1A, that is for extraordinary ability people. EB1B for outstanding researchers and professors.
Correct.
There is another category called EB1C. This is for multinational managers or executives.
Oh, I
So
see.
the EB1C, the one you are asking, for example, one person is working in India in Deloitte.
Right.
If he wants to move to USA, Deloitte,
Right.
and he should work in India as a manager at least for 1 year.
1 year. Okay, got it. Got it.
Then they can come here and work in the same designation for more than a year. Then they can process under EB1C. The tricky part here is like EB1C is having like a huge number of applications in the queue, because like there are like many executives and managers from India. So they are also came to the USA and applied for a green card under EB1C category.
Correct. Normally, how long that will take roughly? Earlier, it used to take 1.5 years. I don't know now, maybe kind of more because you are saying it's in queue or something.
Yeah, even for EB1C, if your priority date, for example, 2024, it may take another 3 to 5 years.
I see.
To become your priority date as current, even under EB1C.
Okay, got it.
So the best bet is if you want to go for EB1, EB1B is the best choice. But there are like criteria which you have to meet to apply under EB1B.
Correct.
But the competition, the number of applications under EB1B are less comparatively EB1A and EB1C.
Got it. Very clear. Thank you. Thanks for the explanation.
No
Thank you.
So the next one is benefits of employment-based first preference green card category, EB1B. It has all the benefits like EB1A, except it requires the employer sponsorship. You should have a full-time position, full-time job offer from an employer to conduct research in your academic area. That is the major requirement for EB1B, and you should have a research experience, or you should have some kind of like teaching experience. So this is also having benefits like permanent labor certification is not required, lesser or no wait time, family benefits, and priority processing and direct pathway to green card. And another major advantage with these categories is even if your petition is denied, your visa status will remain unaffected. For example, you are working on H-1B, you filed EB1A category visa petition and it was denied for some reason. and you can still continue working under H1B without any delay. The third one, benefits of employment-based second preference green card category, EB2 NIW, national interest waiver. There is a EB2 regular category which requires advanced degree or exceptional ability, but the major difference between this one and the regular EB2 category is that one requires employer sponsorship. You need a job offer. For this EB2 NIW, you don't need employer sponsorship. You don't need a job offer. You can do your self-petitioning, and you don't need to file your permanent labor certification under NIW. But you have to meet a couple of criteria which are designated by USCIS, and I'm going to discuss those criteria in next slides. And this is also having benefits like your spouse and children under 21 will get their green cards and the direct pathway to green card. And this particular category is more useful for the people who are not having any kind of visa. For example, you are an F1 visa, but you have your field of endeavor has national importance, and you also have substantial merit in that field of endeavor, and you want to continue working USA. In those cases, instead of depending on H1B visa, you can file EB2 NIW. Once it is approved, you can look for other options. Because with EB2 NIW, when you want to change an employer, you don't need to file again LCA or I-140 each time. That is the one major advantage with this visa category. The fourth one is benefits of non-immigrant visa petition O1A. O1A, most of our Indian professionals not aware of this visa category. This is an alternative option to the H1B, and it is not based on the lottery system. It is only based on the merit-based system, and there is no annual cap on number of visas per year. So it can the USCIS can approve unlimited visas in every year, and there is a flexible duration. You can renew your visa throughout the life. And family benefits, you can bring your spouse and children along with you. And the only disadvantage here is your spouse cannot work when you are on O1A visa. Any questions?
So this is a non-immigrant, so you can have, is this a lifetime visa kind of thing? So you can come and go under that kind of thing. Are you able to work on the non-immigrant visa?
Correct. Yeah, it is for working.
It is
You
work
can
on
work here,
okay.
and you can renew your visa throughout the life.
Mhm.
You can go to India on vacation, come back. So you can do everything what you are doing under H1B visa.
Okay.
But
Right.
this particular visa is only for the merit substantial merit people.
Got it. Okay. Which one out of these four you acquired through EB1A or B?
EB1B, outstanding researcher category.
Okay. Got it. Thank you.
This category EB1B is for internationally recognized outstanding researchers or professors.
Okay. Got it. Thank you.
So the green card application process for petitions filing under EB1A, 1B, and EB2 NIW categories. It is a two-step process. Step one, you have to file your immigrant visa petition, which is I-140. Once that is approved and your priority date becomes current, you can file for adjustment of status if you are in USA, that is I-485. If you are in a foreign nation, and you have to go through the consular processing. This is like eligibility criteria for EB1 extraordinary ability category. Employment-based first preference EB1A green card. It is available for individuals with extraordinary ability in the fields of science, arts, education, business, and athletics. To demonstrate that you have sustained national or international acclaim and your achievements have been recognized in your field of endeavor, you must either include evidence of one-time achievement like Nobel or Grammy or any Olympic award, any other that level of awards can be provided as evidence, or else you have to prove that you are meeting 3 out of the 10 listed criterias. The first, these I-140 petitions are reviewed in 2 steps. One is objective analysis, first step of evidentiary review. In this stage, USCIS adjudicator will see whether you are meeting 3 out of the 10 listed criteria, and it is objective. It is, they will check each and every kind of criteria individual, and they will make sure you are whether you are meeting those criteria or not. The first, I'm just explaining the criteria, the 10 listed criteria under this category. The first criteria, evidence of receipt of lesser nationally or internationally recognized prizes or awards. These under this category, you don't need to have a award like a Nobel Award or anything like Olympic medal or Grammy Award. It can be a nationwide recognized prizes, maybe from the technical competitions or from the symposiums or from the international conferences. Any nationwide or internationally recognized prize in your field of endeavor, you can show those awards as evidence under this criteria. The second criteria, evidence of your membership in associations which require outstanding achievements of their members. Under this criteria, the regular paid memberships are not eligible to show under this criteria. You need to have an invitation from the international organization they send, because they have seen your outstanding contributions to your field of endeavor, and they need your help to advance the your field of endeavor. So it is a free membership, and those memberships are at should be at a higher level, like fellow membership or honorary or some kind of board memberships. Those memberships can be shown under this criteria to argue that you are meeting.
Such as IEEE, right?
Example, IEEE, if you have a fellow award from IEEE, you can show that one. Maybe like if you are a elected membership, every 2 years they conduct elections. If you like elected as a director or a board director or some kind of electoral positions, and then you can show those as evidence, and you have to provide a clear narration that at that designation what you are doing and how you are progressing your field of endeavor, how you are advancing your field of endeavor. That is what you have to prove under each criteria. The third criteria is published material about you in professional or major trade publications. So in the major media, about your work or about your contribution to your field of endeavor, if there is a published material, you can show that as an evidence that you can argue that you are meeting that criteria. The fourth one, evidence that you have been asked to judge the work of others, either individual or on a panel. For example, if you have participated in a technical competition to judge work of others, it is in your field of endeavor, then you can show those documents as evidence that you are meeting this criteria. The fifth one, evidence of your original scientific, scholarly, or business-related contributions of major significance to your field of endeavor. For example, you are in IT industry, you developed some kind of application which is widely used across the nation, across the many countries, and it is creating so much business to your organization. Then you can show that as an evidence, like you have contributed to the business of that organization. Or else, like if you have innovation, like if you have some kind of technological advance to your field of endeavor, you can show all that evidence as for the argument under this criteria.
So
The sixth,
okay, you continue. Okay.
no problem.
The question is basically, are these any of the combinations, or all of them, or some of them?
As I said, it is like 3 out of the 10 listed criteria.
Oh, 3 out of 10. Okay, gotcha. Yeah, I missed it.
Any three. So the sixth one.
Yeah, one example, Krishna, to make sure, right?
Okay.
Suppose I'm working in engineering college as a professor, and I went and do some kind of research work for maybe in industry. They want to do some analysis, then I go and do that, and then that industry recognized, he has done a good job or something. That kind of things will help too for professors if somebody want to come.
Yeah, it is helpful. That is under EB1B category.
Mm-hmm.
For example, if one professional working as a professor in India at IIT Madras, for example, they conduct, there is a funding for the research at IITs. They conduct research for over the years, and if they have any kind of scholarly articles or any kind of awards for their research, and they can show those as evidence, and they can ask for approval.
Okay. Good.
Okay. So the sixth criteria, evidence of your membership of scholarly articles in professional or major media publications. It is like you published some kind of research article in international journals or nationally popular journals. Those evidence you can show under this criteria, but you should have at least 5 to 6 research articles. If you don't have research articles many, you can show your international conference papers or symposium papers. Like if you have given any kind of seminars at the symposiums, and if you have published any kind of conference papers, then you can show under this criteria. And the seventh one, evidence that your work has been displayed at artistic exhibitions. This is for the arts field. That's for like a television industry or motion industry people, professionals. And the eighth one, evidence of your performance in a leading or critical role in distinguished organizations. For example, you are working in a Deloitte and you are performing a critical role or a leading role, means a manager level or some kind of technical leading role, then you can show that one as the evidence under this criteria. And ninth one, evidence that you command a high salary or high remuneration in relation to others in your field. This one, USCIS has metrics for each job location. For example, you are working in Houston and you have some SOC code. They have the median salary, they have the higher salary, the maximum salary. They will compare your salary at what percentage when it compared to the higher salary, the maximum salary. It should be in at least 10%, within 10% from the top salary. For example, if the person is the maximum salary for your SOC code and the job location is 200K, you should at least get 170 plus. It is like that salary is the base salary plus benefits like bonus or other benefits. The summation we are talking about here. So the 10th one, evidence of your commercial success in the performing arts. This is for the arts field. As I said before, it is this arts field. There are like 2 criteria available for them. Specific to the arts field, it is for a television industry or motion pictures industry people. The second step of evidentiary review, this is the subjective analysis. Here, the USCIS adjudicator will look in the totality of your petition. They will make sure all the criteria you are meeting in the same field of endeavor. For example, you worked as a mechanical engineer, you published some kind of articles when you studied, and then you shifted to the IT industry and you are playing critical role, you are commanding high remuneration, and you have some other awards in IT industry. Then you cannot combine these awards with your mechanical engineering background research articles. So all your evidence should be in the same field of endeavor. That's what they want to make sure. They will make sure. And they will also make sure that you have sustained national or international acclaim, and they will see whether you are at the top of your field of endeavor to advance your field of endeavor. And they will also make sure like your intent is to continue working in the same field of expertise. and your presence will be substantially benefit the USA. If the adjudicator convenes with all these points, they are going to approve your I-140 under EB1A category. And the next one now is EB1B. This is for the outstanding researchers and professors who are internationally recognized. Under this category, you should have a full-time employment from the research-based organization or from the university which conducts research in the academic field. And apart from that, you also have to meet 2 of the 6 listed criteria. All these 6 criteria actually are there in the EB1A criteria, but these are very specific to the research, so they kept these criteria under EB1B category. The first criteria is evidence of receipt of major prizes or awards for outstanding achievement, and it is the same explanation as I have given for the EB1A. All these criteria are same. The same explanation goes here too. And I'm just reading the criteria here. Evidence of membership in associations that require the outstanding achievements of their members. And published material in professional publication about aliens' work or about alien. And the evidence of participation as an individual or in a panel to judge work of others in the same or allied academic field, and original scientific or scholarly research contributions to your field of endeavor, and the authorship of scholarly articles or books in your field of endeavor. This one, as I said before, it requires at least 3 years of research experience or teaching experience in the academic field. And you should have a full-time offer from the research-based organization or from the university which conducts research in your academic area. And the second step of evidentiary review at this stage, they are going to check whether you are internationally recognized as outstanding in your specific academic area. And they will also check the qualifying status of your employer, whether your employer is private or public sector employer, but they should conduct a research. That's what they will check. And then they will also check the offer letter, whether it is a full-time offer letter or it is a contract-based. If they convince with all your evidence, they are going to approve your petition under EB1B. Here, this is EB2 NIW. EB2 NIW is another visa option under EB2 category. There is a EB2 regular visa category that is most of our Indian people go with, who have advanced degree or bachelor's degree with 5 years of progressive experience. Under the regular EB2 category, you always depend on your employer. And every time when you change your employer, you have to file your permanent labor certification process, which generally takes anywhere between 6 to 12 months at this time. And then you have to file your I-140. It is a long time taking process, and it is involved so much of finance, like money. And if it is EB2 NIW, if your visa petition is approved once, and then you don't need to file for labor certification process, and when you change your employer, you don't need to file I-140 again and again. But you have to meet certain criteria designated by the USCIS. It has 2 levels of qualifications. The first basic level is you should have an advanced degree, which is master's or PhD degree, or bachelor's with 5 years of progressive experience. Once you meet that basic qualification, and the second stage is you have to meet the USCIS designated 3-prong test to qualify for NIW, that is called matter of Dhanasar. The prong 1, evidence that your field of endeavor has substantial merit and national importance. For example, you work in a cybersecurity, maybe you are working for artificial intelligence or energy industry, healthcare, any. I'm just quoting some examples, but there are many endeavors which are having national importance. If you work in those fields, you can claim that your field has national importance. At the same time, you need to provide evidence that you're having substantial merit. Then you meet the prong one. The prong two is you have to provide evidence that to prove that you are well positioned to advance your field of endeavor. For prong one and prong two, to convince the adjudicator, you need to make an argument with a clear narration, and you have to provide evidence. Most of the time, like to convince the adjudicator, you will provide the evidence which are given for EB1A and EB1B. Like if you have published some kind of articles, you can show here as an evidence that you have did some kind of conduct some research and you found some innovation and you publish some materials, and then you can show that you are well positioned to advance your field of endeavor. And you have been asked to speak at the international conferences, and you have been awarded at many conferences, many technical competition. Then you can argue that you have a substantial merit in your field of endeavor. And prong three, on balance, it would be beneficial to the USA to waive your job offer, thus the permanent labor certification requirement is waived. You should meet the basic qualification. Along with that, you should also meet all three prongs to approve your petition under EB2 NIW. Under the basic qualification, if you don't have advanced degree, or the advanced degree or bachelor's with 5 years of progressive experience, then you have another option, like you need to prove that you have exceptional ability, that is having like 6 regulatory criteria. You should meet at least 3 of them. If you don't have advanced degree and if you don't have bachelor degree with 5 years of progressive experience, it is rarely you will meet the 3 out of these 6 regulatory criteria. And these criteria more or less similar to the criteria given for EB1A and EB1B. The only thing you need to remember, EB1A and 1B are having higher standard. You need to have like significant achievements in your field of endeavor to approve under EB1A, EB1B. But EB2 NIW, you don't need to have that level of expertise, but you have some kind of significant contributions to your field of endeavor. In that case, you can file under EB2 NIW. This is O1A, non-immigrant visa category. This is an alternative option to the H1B visa. It is unlike H1B visa, it is not depend on lottery system. There is no cap per year for number of visas, and it needs like you have to meet at least 3 out of the 8 listed criteria to approve under this category. O1A non-immigrant visa is for individuals who possesses extraordinary ability in the field science, education, business, and athletics, and has been recognized nationally or internationally for those achievements. O1A extraordinary ability, it is very much similar to EB1A, but the level of expertise needed for O1A is much lesser than EB1A. The eligibility criteria are same as EB1A. If you remember, EB1A has 10 listed criteria. Out of those 10 listed criteria, 2 criteria are very specific to the arts field, television industry or motion pictures industry people, professionals. If you remove those 2, the remaining 8 are the criteria for O1A extraordinary ability. The only difference is, if, for example, like if you go for like criteria high remuneration, for your job location and your SOC code, for EB1A, if you need to have at least 180K salary, for when it comes to the O1A, even if you have 130, 140K and you are meeting other criteria, then it will be approved under O1A. In other words, like I'm just telling, like it is not high standard as EB1A, but still you should have some kind of significant contributions to your field of endeavor to approve under O1A category. The evidence criteria, here I listed 8 criteria which are very similar to EB1A criteria. We accept those two criteria which are there for arts field. Evidence of receipt of lesser nationally or internationally recognized prizes, evidence of your memberships in international or nationwide associations in the fields which demand outstanding achievements, and evidence of published material about you in professional or major trade publications or major media, evidence that you have been asked to judge work of others, either individual or on a panel, evidence of your original scientific or scholarly or business related contributions to your of major significance to your field of endeavor, and evidence of your authorship of scholarly articles in professional publications or international journals, and evidence of your performance in a leading or critical role in distinguished organizations, evidence that you are commanding high remuneration. Most of the people knows the benefits of having green card. You don't need to renew your H-1B visas, and all your immediate family members and your, that is like your spouse and children who are under 21 will get their green cards, and you will be eligible for unemployment benefits, and this is the first step for USA citizenship, and the protection from deportation, legal protection under USA laws, and ability to sponsor family members, and easier travel, ability to work and live in USA, and is eligible to get the federal benefits, and you can become an entrepreneur and you can engage in politics. What we do at Way2 Green Card. Way2 Green Card is a professional services company. We have collaborated with the top USA-based immigration law firms. And if you choose to go with our attorneys, you will get substantial discount on the legal fees. Our attorneys will work for very nominal fee if you compare with the market price. At Way2 Green Card, we conduct a free quick consultation. We provide detailed profile evaluation. We also provide sample petitions and sample recommendation letters, and we will provide guidance for crafting effective recommendation letters, and assistance in building strong petitions. And we also we assist in creating improved write-up for the final merits determination section, and strategic planning for each case to meet maximum criteria, and documentation assistance. If you choose to go like self-petition, you don't want to go with any attorney because you don't want to pay for the legal fees. In those cases, we will provide everything from our end, and we will give assistance from start to end. And we will also help in filing your I-140 to I-765 applications, and we will charge very nominal fee at our organization. And if you like to go with our collaborated attorneys, you will get a substantial discount on the legal fees. And the services what we provide at Way2 Green Card, we help individuals who are having substantial merit and national or international acclaim in the fields of endeavor, sciences, arts, business, education, and athletics. For self-petition green card categories EB1A and EB2 NIW, and employer-dependent green card category EB1B, and employer-sponsored or self-sponsored non-immigrant visa category O1A. And I want to tell you O1A visa about O1A visa. If you don't find any employer to sponsor O1A visa, you can establish your own organization, your own firm, and you can create a roadmap, and you can get some fund. You can raise some funding, and then you can provide that as an evidence, and you give clear argument with narration that you can do some kind of advancements in your field of endeavor. If the USCIS adjudicator convinced with that, without having any employer sponsorship, you can get approved your O1A visa. O1A visa, that is all. Yeah. And yeah, for any of these categories, these are like for high achieving individuals. So you need recommendation letters from top people in your field of endeavor. you're claiming like you're outstanding professor, or you're outstanding a researcher, or you have extraordinary ability in your field of endeavor, it means that you know some people who are at the top in your field of endeavor. So USCS is looking for some kind of recommendation letters from those individuals. uh, they have to write a recommendation letter saying that they know your credentials, they know your achievements, they came to know you with your work published somewhere in the media, or somewhere at the conference, some level of through outstanding achievements of yours. So for any of these kind of criteria, you need to provide a recommendation letters along with the evidence to prove that you are meeting under these criteria. This is the contact information of our professional organization. And please do remember that we are not attorneys. We don't provide any legal representation from Way to Green Card, but we have collaborated with top immigration attorneys. You can choose them for legal representation. If anyone want to contact us, you can contact through our email support@way2greencard.com, and you can also text us at 979-588-2676. You can also view our website www.way2greencard.com. I am open for questions.
So, is there any age criteria for the EB to NIW, like for the master students who completed?
Tell me again, you're asking for the criteria for EB to NIW?
Yeah, EB to NIW,
Okay.
like after complete just the master's degree, or else you need the any age criteria for that basic criteria.
For EB2 NIW, there is no age criteria. It has like as I said before, you need to first meet the basic eligibility. That is like master's or PhD, or bachelor with 5 years of progressive expertise. Once you meet that one, you have to provide evidence that you are meeting all three prongs. The matter of Dhanasar, it called, to qualify under NIW. So the prong one, evidence that your endeavor has substantial merit and national importance. So for this one, I will go to the criteria under EB1A. For example, you are working in energy industry, oil and gas industry. It has national importance. Oil is playing very critical role in the world. So you can claim that you can argue that your innovation in for example, myself, I'm working for offshore oil and gas industry. We design and develop mobile offshore drilling units. Those units go into the deep sea, and it will drill oil, and the oil will be transferred to the shore, and then it will refined, and then it will go to the it will go to the people. So we have significant effect on people lives in day-to-day lives. So I can claim that my field of endeavor has national importance. So and substantial, when it comes to the substantial merit, the criteria always you can use for EB2 NIW, the criteria given under EB1A. The only thing is like EB1A is like needed like higher standard merit. For example, you have received some kind of international recognized award. Only one award, but that you have received in 2024. USCS adjudicator may not convince with that, because they need substantial merit. It means that sustained national or international acclaim, they need that. It means that over the years, maybe like from past 5 years, maybe from past 3 years at least, you have a sustained national or international acclaim. You have achieved an international award in 2021 at some international conference, and at the same time you have achieved another international award at 2020 in 2023, and again 2025. In that case, they will look at all these three awards. They will see that you have a sustained national and international acclaim, because you have received awards in multiple years.
Got it. Thank you.
So it's like you can use all these criteria which are given under EB1A to argue for EB2 and EB2 NIW.
Yeah, thank you.
For professionals who want to go with any of these criteria, I would like to suggest that you try to understand clearly all the criteria given under EB1A, so that you can make a clear argument, and you will come to know what kind of evidence you have to provide to convince the adjudicator.
Wonderful, wonderful. Any other questions from anyone? Alrighty. Thanks. I'll take the silence as no. Krishna, thank you very much for the very valuable information on the immigration. Though I sailed the boat, but I think this is very valuable information that you provided here that helps a lot of young talent out there who are seeking the green card process and the dreams of having the green card process. I know this is a very touchy subject. A lot of things are changing so fast. I think some of those things are already covered by you, Krishna. I think thank you very much for everything you've done here. Before I sign off, any other last minute go backs from anyone?
Thank you, Ravi Garu, for giving this opportunity. You provided a right platform to discuss about these visa categories, which are much needed at this stage, because there are many regulations changing for H1B visa. There is a 100K fee for H1B visa for the new petitioners, which is really not good for new petitioners. And there are many rules and regulations coming for F1 visa and other visa categories. O1A is the best bet for F1 visa candidates and people who don't have H1B visa. That is the best option. O1A at first.
Timing is impeccable, right?
Mhm.
It is that buzz going around, and I think there's a lot of shock waves around on this. So there's so many people who are lined up for this kind of opportunity. So
Correct.
yeah, we will definitely share with this with the rest of the community, and they can pursue this and look into this. And if there is any further questions, so they can definitely reach out to you.
Sure.
Again, thank you very much, and thanks for
Hi,
all the things you've done.
Yeah, my pleasure, sir. Thank you very much.
Vikash, you have some question?
yeah, I'm so sorry to cut you. My mic has an issue. I think you guys can hear me, right?
Yes.
Yes.
Go ahead.
Yeah. Thank you so much, Krishna Garu, and everyone who conducted this by doing this. This is like right time to do that. So I have a quick question. As you all know about the new rule going to pass about H1B from next year, I guess. So is that eligible for people who are outside the country, or it is applicable for who are here, who are converting from F1 to H1, like it's applicable for everyone, or like only from outsiders?
Yeah, this question should be for the attorneys, but I will answer just for information. As my understanding, I have agreement. We have collaborated with many law firms. So what they told us is this is for the foreign nationals who are in foreign nation and trying to come to USA on H1B visa for the new petitioners, not for the petitioners who are in the USA and already having H1B visa. They want to transfer to the different employer or something. I'm not sure about the F1 to H1B visa because the regulations are not clear at this stage. Some firms are saying it is not for F1 to H1B, but some firms are saying that it is also for them. That is not clear at this time.
So the information is still has to be clear from the State Department.
Yeah, I think
Correct.
there is a lot of confusion on this question from, but thank you so much. And I have one last question. That is like I'm on my full time right now. But my employer, I'm not sure they are willing to sponsor me at this point. What do you suggest me to go with if I'm planning to go for another visa apart from
Yeah,
H1?
this is all based on your profile, your field of endeavor, and your achievements. I can provide, like, if you send your updated resume, I can provide the quick consultation by looking at your resume, and we can decide like which visa category is more suitable for you.
Okay.
So even though you work in a full-time job, but you should meet some certain criteria which are designated by the USCIS.
Okay, sure,
Yeah.
sure. Maybe I will share my profile, then maybe we'll get a clear idea
Yeah,
what
I
to
gave
suggest.
here my contact information so that you can use this, that support at way2greencard.com. You can email your resume so that I will review it, and my team will review it, and will come back to you.
Sure, sure. Yeah, thank you so much, Krishna, and
No
thank
problem.
everyone for doing this. Thank you.
Any other last minute go backs from anyone? Thanks everyone. Thanks for attending, and thanks again for Krishna Garu for doing this. Okay, take care. Have a good day, everybody.
Thank you all.
Thank you. Thank you.
Bye.